Ken was seminal in the development of medical law and ethics, not only in Scotland but also in the UK, and was well known internationally. So that is the origins of the Mason Institute, and what we try and honour in terms of the activities and the research and the networking that we do, and particularly these sorts of events such as the Great Medico-Legal Debate. Not only do we have a great array of students here, we've got connections to the profession, and we're very happy that Drummond Miller are sponsoring prizes and came along and gave their time to adjudicating. So I need to thank Darren, Lisa and Lindsay for offering your time to do that. It's really, really much appreciated. As we know in the area of medical law, you know, we're dealing often with real-world problems in the teaching of it, and also having that interaction with people that are in practice and understanding both dimensions is a really important part of what we like our students to learn about as they undertake their undergraduate work as well as their master's work. Without further ado, I would like to introduce our finalists here. Well done for getting to the finals here. I know you've been nervous, but you're very well prepared, and it's been wonderful to hear you present. I would also like to introduce our judge for the final, Lord Carlaway. Be good, do your best. And he will be adjudicating on your presentations. We'll give him some time to make his decision, and then we will all rejoin for the big announcement. He'll also be identifying the best debater in the grand final as well. And we have separate prizes for that as well. And just before I do finish, I would like to thank my colleagues, Dr. Ted Dove and Ms. Ruby Reed-Berry, where is she gone? There you are, for their wonderful organisation of this event. As I say, we couldn't host it last year, and we've got a new format as well. And you've done an amazing job between the both of you. I really want to thank you for all the work you've done and for the support for the students as well. So without further ado, I hand over to our grand finalists, I should say. Good luck. I'm sure you do well.
Thank you very much, Professor Farrell. Right, but without further ado, shall we get started with the final round, round 3? And of course, that commences with team member 1-4, who will open their arguments. Ruby will be timekeeping for us, so everyone please look for the hand signals from my colleague Ruby. Team member 1-4, whenever you're ready.
Good evening, my lord. So our team are arguing that children ought to have the right to try experimental treatment when this would not cause significant harm to them. Our first argument stands on the basis that children are very different to adults. In the past, it was acceptable to use adult research for children, but this is wrong on so many levels. As some of you might think, children are not just small adults. Their bodies work entirely different, and they undergo many changes as they grow into adulthood. The human body's anatomy, physiology, and response to drugs vary with age. So experimental treatment is essential to prove the effectiveness of this treatment and to understand diseases in all ages, not just adults. The World Health Organization has described children as a unique population, so trials are essential to develop and improve treatments for the child. It is clear that adults can provide the same knowledge of many diseases and illnesses. Certain diseases are more prominent in children than adults, and that is where experimental treatment is absolutely necessary, such as acute lymphoblastic leukemia, for example. This affects kids almost exclusively, with over 95% of those affected being under the age of 5 years old. These children deserve to have the best treatment that they can get, so experimental treatment is necessary so they can understand the diseases in these 5-year-olds. Our next argument stands on the basis of off-label medication. So UK healthcare already use and treat children with medication that is not licensed specifically for their age group. And this is due to the lack of paediatric-specific data in relation to doses, efficiency and safety. These are labelled as off-label and they are not licensed. Until further research, doctors are forced to prescribe off-label medication to kids. The UK Study Paediatric Care Unit showed that 70% of all patients in this paediatric ward received at least one dose of unlicensed drugs. Essentially, off-label medication is experimental treatment, as we don't know the potential benefits and side effects to that child. Off-label medication is used so frequently, more than you would imagine. and improves the treatment range available for all these children. Without these, there are very few options available for children. If we don't allow experimental treatment, doctors are very limited with treatment options, and a child would benefit from the best treatment care available. Our fourth argument lies on the basis of benefits to the child. So I want to ask you a question. If your child was dying, had tried every licensed treatment option with no luck, then surely everybody in this room would agree that the child has the right to try experimental treatment for the last glimmer of hope. It might save their life. I want to introduce you to Liam Scott, who travelled to New York after being diagnosed with neuroblastoma cancer when he was only 5 years old. This affects about 100 UK children every year and requires aggressive treatment in the UK. Liam faced rounds and rounds of painful treatment in the UK which was not promising. So him and his family decided to go to the USA to get experimental treatment that the UK would not offer, and he is now cancer-free and can live as a kid again, not in hospitals. How can anyone tell me that Liam had no right to get this treatment because he was a kid and it was experimental? It saved his life. This treatment was his guardian angel. Experimental treatment reduces mortality rate by driving clinical research. How can you argue against this? The current and future generations of children are relying massively on experimental treatment taking place. Cancer is the monster of death for kids, and there's been progress over the years which proves excellence for this experimental treatment. There's a remarkable 75% of children with cancer today will live long term, and this advancement is due to experimental treatment in children and clinical trials. So, modern medicine is how it is today because of experimental treatments. There would be no hope for the future of medicine and the future of our children if it is not allowed. There would be a standstill. The generation of kids and the future generations of children rely so heavily on this. How can you tell a child they have no right to try cheap treatment that could save their life? It might save them, it might not, but for some kids this is the only chance that they have. So don't take away their chance. Don't take away this only hope for children. It's not right refusing children the chance of a better life. Thank you.
My Lord, members of the House, I thank our colleagues for their opening remarks. I'm Karan, and with my colleagues Katie and Jordan, we shall be arguing against the motion that children have a right to try experimental treatment where it would not cause significant harm to them. Now the motion, as my colleague said, textually seems to apply to a very specific type of end-of-life choices. But experimental treatment encompasses a wide range of medical activity. It could be proto-scientific methods of externally applying herbs to your body, to something like nucleoside bypass therapy. The conditions these treatments can cure themselves range from mild asthma to untreatable cancer. To these diverse range of experimental treatments and the diseases, the diverse range of diseases they seek to cure, my colleagues would apply a singular and a fluid legal concept, significant harm. In this debate, our arguments rest on these three pillars: the subjectiveness of experimental treatment, the subjectiveness of the underlying conditions they seek to cure or manage, and that of significant harm threshold. Now, the motion impacts differential experimental treatments differently, the ethics of that differently. For cancer, both Indian Ayurveda medicine and the Native American shamanistic medicine would give you some herbs to apply to your body. That would not cause you any harm, and you can continue that with your established medical treatments like chemotherapy. Alternatively, some advocate that you should intake something called cesium chloride, which is a toxic salt, because apparently it kills cancer. It not only does significant harm, and not only fails to cure cancer, but actively increases the chance of cardiac arrest or hypokalemia. Cancer UK and American Cancer Society both say that you can go for traditional herbs as long as you're also going on with chemotherapy, but they would be certainly against something like cesium salt. The ethical permissibility of the broad range of activities that are experimental treatments is so different that the motion does them injustice by reducing them to two single syllables of yes or no. Now, as a parent, the ethics of this motion's application to various conditions itself differs. When it is an end-of-life decision, perhaps there's nothing to lose. And perhaps, as you rightly said, you could have an experimental treatment because there's no possibility of some significant harm. Now compare this with someone like me who has lifelong asthma. Now there are Ayurvedic doctors, homeopaths, naturopaths, and other snake oil salesmen who would be willing to sell me some medicine at the exclusion of established medicine. And they would want me to take it. I had to live with this condition, I had to manage it somehow. But these pseudoscientific methods would inherently exclude established medicine and end up harming patients like me in the long run. To these complex issues, the motion somehow offers an ethical binary. Now, another significant issue here is reliance on significant harm. It's perhaps easier to brush off quackery of proto-science as something that would cause you significant harm or otherwise. But there are several established treatments, experimental treatments, that are in the nascent form of medical experimentation, in the bounds of modern science. A pedantically taken experimental treatment does mean medicine that is not yet approved by medical regulators for regular use. But that is simply the point. The medical faculties do not know what it is, how it affects different age groups, different ethnicities, different social groups, and so on. How is a doctor or a judge to decide what is harmful and what is not? Further, to decide what is significantly harmful and what is significantly not harmful. The motion flips the doctor's established role in our society on its head by making experimental treatments a matter of right for the patient, at par with their positive right to choose any other established treatment. My lord, the foundation of modern medical ethics is the birth of the distinction between a curer and a killer, a sorcerer and a doctor. It is the reasonable certainty of a proposition and the admitted infallibility of modern science that establishes an ethically established medical faculty. To scientific methods, exercises caution and proposes experimentation. To pseudoscientific malarkey, it keeps its doors closed. The motion destroys that carefully crafted, constantly challenged and imbued system that we put our faith in and simultaneously can be skeptical about. By blurring the bounds of established medicine and by equaling the ethics of anything under the sun that encompasses experimental treatment, this motion unintendedly blurs the line between the curer and the killer, between the sorcerer and the doctor. At many points in history, that blurring impulse has arisen in society, but we must always defend medicine and society against these impulses. Thank you so much for your time.
Hello, my lord, and everyone else here today. My colleague makes some good points. I am not at all saying that herbal medication should be the only treatment they use, and I'm not saying we should promote them. However, the truth is, current pediatric drugs are not enough. We need to use drugs off-label, because if not, how would we treat children? Because the only way to get licensed for those medications is to do clinical trials. People don't like doing clinical trials on kids, because it could be seen as harmful. To be honest, I promote clinical trials in children, but I also know there are limits. You can't test how much someone will choose an inhaler, because are you going to let that child have an asthma attack? No. There are limits to medications for pediatrics, and there's a reason that doctors prescribe drugs off-label so frequently to this age group. Especially among neonatals. 70% of drugs used in neonatal were off-label. This is because there's nowhere near enough clinical trials for that group. The doctor is using their clinical judgment to make a decision. And that's what we want. We want doctor-led decisions, like clinical trial drugs, or like off-label medication decisions. I'll also point to cancer treatment for children. Many treatments for children with cancer are clinical trial regimes. This means they're all experimental drugs to an extent. We don't know if it'll be entirely safe, it'll have the best outcomes, but due to this, we're able to progress in medicine. Due to this, we've increased the survival rate from children with cancer from 70% in the 1990s to 90% today. This wouldn't have happened without these experimental regimes. You are slowing down progress of medicine by saying everything must be licensed. I'm saying let doctors use the drugs they need to use to treat children, so there are a range of treatment options, so that they can survive cancers that would have killed them 30 years ago. I want to point to some of the most common off-label drugs. Salbutamol. You might say it sounds familiar. It's from your blue inhaler for asthma. As my honourable colleague here said, he has asthma. Would you let the child have an acute asthma attack, or have worse asthma throughout their life because you don't want to give them a stronger dose of salbutamol? Another is paracetamol. Would you leave that child in pain because that specific dose hasn't been measured in that child? When as a doctor, you know by clinical decision that it's better for that child to be out of pain, but to have the benefit of that treatment, even if it is unlicensed. The BMA, British Medical Association, admits this. It knows doctors do off-label medications for paediatrics, and it knows it is for the right reason. This is why doctors aren't usually sued for using off-label medications, despite it being an unlicensed medications. Parents accept this risk because normally it benefits their children, because there are not enough paediatric clinical trials to try every single drug in every age group. We are working on drugs that work in adults or work in other conditions, so we know they're safe. They've had drug safety studies, they've had animal studies, and they've had stage 1 human studies, so we know they don't cause significant harm. We're trying these drugs to give children a chance, not only for end-of-life decisions, but for a range of treatment options. For example, migraines. Most migraine prophylactic drugs aren't licensed in children. Would you rather leave children with chronic migraines for their childhood until they turn 16 and suddenly are licensed to have the medication? It's all about being for the best interest of children. If they're not at significant risk, it's in their best interest to have these options. I would finally say that with Gillick competence, these children might be able to make decisions themselves, or the parents might be able to make the best decision for that child. I don't see the point in limiting our treatment options, limiting our survival rate, and limiting progress of medicine by saying that all drugs must be not experimental. They must be licensed for that specific purpose, for that specific age, for that specific weight, for that specific dose. It'll never happen. You'll never have that many pediatric clinical trials. Thank you.
Good evening. I'm John Littlehouse and I'm an LLM Innovation Technology and Law student here. I'd like to start off by reiterating that we are not against experimental treatment in any way. We're against significant harm as a threshold for establishing whether experimental treatment should be applied. First of all, I'd like to respond to one of the arguments raised by Matt. Children and adults are, of course, manifestly different. However, we would argue that the best way to establish whether or not the response of a child to certain drugs is not through experimental treatment when there is very little scientific evidence regarding their effects on children, but rather to increase pediatric involvement in clinical research, which is very different from establishing a right to experimental treatment. Further, I'd like to argue that this concept of significant harm is far too nebulous to be an appropriate standard for decisions of this nature. There are two reasons. Firstly, experimental treatments are experimental precisely because of their lack of solid evidence regarding their ability to do harm or to do good. As was mentioned earlier, leukemia in children. There was a clinical trial for cancer immunotherapy where engineered T cells were used to kill malignant B cells. On paper, this obviously sounds like something which would do way more help than harm. However, in the experimental treatments, we found that there was a significant barrier to doing no harm in the experimental research. There's always a risk of it, because it's precisely because it's experimental. And in the malignant B cells case, it causes cytokine release syndrome, as all of the cells which are engineered to attack cancer cells attack every other cell in the normal body. It led to multiple organ failure in sepsis. Fortunately, well, not fortunately, this was only in adults. But imagine, as you mentioned, the last Glimmer of Hope, where a parent suggests that their child should go for this medical treatment, precisely because there is no other thing, only to watch their child die of multiple ring-related sepsis. Furthermore, experimental treatment is an incredibly broad category. It ranges from drugs used in animals but never to people, to more rigorously tested medications. Secondly, using significant harm as a metric represents a departure from the best interest test, which is child-centric and appropriate. And as you've mentioned, we should always make decisions in the best interest of the child. An argument based on significant harm was raised in the Charlie Gard case, again, the last member of parental hope, whereas parents sought to take him abroad for experimental and untested nucleoside therapy. Best interest allows evaluation of parental wishes to be considered along with the views of the child, and as you mentioned, we love doctor-led decision-making. It also allows the views of the clinical team to be taken into consideration, and what would least restrict the child in the future. It inherently makes the child's welfare a focal point of discussions regarding treatment. Significant harm, however, represents nothing more than a misapplication of the doctrine of the harm doctrine to that of parental autonomy, where it should not extend. Not only this, but it fails to consider that lack of significant harm is in no way an admission that this therapy will confer a benefit, or that it will stop harm from occurring. In the Charlie Gard case, the significant harm in the metric was prolonged suffering would have gone on even longer, even though there was absolutely no way that the experimental treatment which was put forward for would have benefited him. While parental autonomy is important, it's also worth noting that the significant harm test may be used to undermine this. There are academic concerns that widespread employment might cause a chilling effect on the role of parents in clinical decisions. As in A Child, the test under Section 31 of the Children Act led to a local authority pulling up almost every instance of parental disagreement in a way to undermine the parents and strengthen their case. This may lead to parents in the future being unable to speak up for what is in the best interests of their child.
So the opposition has already depicted the alleged dangers of experimental medicine. We've almost had quite an Orwellian portrait of the pseudoscience and the snake oil salesman, you know, I took a drug and it gave me cancer. But is this really the case? Significant harm, they say, is a threshold that they take umbrage with. And I get that they think it's reductive, but that is in the parameters of the question. It says experimental treatment where this would not cause significant harm to them, and that has always been the bottom line. And so regardless of these curiosities on the other side of the world that might harm us, it's all about whether or not it causes significant harm. And so that's besides the point, that's irrelevant. Experimental treatment forms the cornerstone of modern medicine, and the field of paediatrics is no different. If the experimental treatment is intended for children, then that's because there are biologically distinct features in this age group that can't be replicated without testing them on children, as my teammates have talked about in acute lymphoblastic leukemia. Clinical trials that still use immunotherapy and engineered CAR T cells are used repeatedly in children, while sepsis is a condition that could lead to suffering and death in children if we don't use unlicensed treatment. If the experimental treatment is intended for children, without these experiments, the efficacy of treatment couldn't be reliably demonstrated, and only progress in the improvement of treatment would be affected, particularly in conditions where children are the most commonly affected age bracket. So long as the healthcare professional properly explains the benefits and the risks, a Gilead competent child can consent to experimental treatment in the same way that anyone else could consent to a routine medical intervention. Also, many treatments that are widely used today could be classified as experimental, as my team has already demonstrated with salbutamol, with paracetamol. Experimental in that they haven't been licensed for use in children due to a lack of research. The research that wouldn't be possible if this were to be passed. Essentially, all of these off-label medications are actually experimental treatments that are used in everyday practice and have enabled the successful treatment of children with a variety of common diseases. Diseases that preferentially target children, are often rarer but more aggressive, and therefore have poor survival outcomes for many of these victims. Experimental treatment is a last resort and can be the difference between life and death for these children. In summary, children ought to have the right to try experimental treatment where this would not cause significant harm to them, because we believe that the advancement of modern medicine, especially paediatric medicine, depends on letting Gilead-competent children have the right to choose their own treatment in their own time. Thank you.
Good evening, my Lord. My name is Katie Feltham, and I am a final year student on the LLB Honours Programme at the University of Edinburgh. The right of children to try experimental treatment has given rise to numerous high-profile cases, which my colleagues here have both discussed, which evoke emotive responses from the public, politicians and clinicians alike. I appreciate the arguments presented by my respected colleagues on the opposing team on their side of this contentious and contemporary debate. My colleagues and I have presented the case against granting children and young people the right to try experimental treatment where it will not cause them significant harm, as we believe the scope of the term experimental treatment is too broad and a test for significant harm too indeterminate and would conflict with Scotland's established approach to matters concerning children, their best interests, which is a more appropriate standard for sensitive and child-centric decision-making in medicine. I would like to begin just by illustrating a way in which my colleagues and I think our respective colleagues in the opposing team might have misunderstood our argument. We are not making a case against experimental treatment outright, nor the ability for children to approach this sort of clinical treatment. What we are saying is that a legal right or professional clinical right to try experimental treatment would be inappropriate in this context. As my colleague Karan illustrated, experimental treatment encapsulates a broad range of both clinical and alternative treatments. It could entail a procedure or medicine which is in its final stages of highly funded clinical development through to a treatment with zero to little scientific credibility. Additionally, the applications of such experimental treatment are broad. We often see cases, and my respective colleagues on the opposing team frequently referenced children who are facing the end of their lives, who are not faced with many remaining options to pursue in their medical care. However, this would also extend in the motion to children with clinically manageable conditions, such as my colleague Karan with his asthma. To say that children like that, who have a clinically manageable condition and would live their entire lives potentially with some complications, but ones that could be treated, would have an absolute right to pursue treatment which may in fact worsen their condition and lower their quality of life, is not the approach we would like to advocate for. My colleague Jordan has talked in detail about the issue of significant harm as a determinant for whether children should be able to pursue an experimental treatment. The first issue is how we can possibly define it. It is an indeterminate term, and the nature of experimental treatment at its core means that we cannot possibly confidently state whether a certain treatment falls within any criteria that define significant harm if we are able to come up with any that we find appropriate. I appreciate the other side's argument and would not deny that children are absolutely distinct from adults, but unfortunately the appropriate safeguards are not currently in place in clinical research, upon which a lot of our opposing sides' arguments turn, as opposed to alternative experimental treatments. Paediatric involvement is drastically underfunded in clinical research, and there are insufficient professionals to supervise each child. Now, we know when we clinically research a treatment or a medicine that we are trying to produce beneficial outcomes for a group and not just an individual. However, we need individual supervision in order to run this research ethically and in a way that is consistent with the law. Because of the lack of paediatric supervision, meaningful research which benefits the wider community cannot ethically and legally be produced. Scotland has a long tradition of placing the rights and interests of children at the heart of many of its laws. A lack of significant harm cannot be equated with conferring an active benefit upon a child. The current law in Scotland places heavy emphasis on the best interests of children and what we most concern them. Significant harm is an objective criteria. Best interests forces us to look at each individual case, each individual child, which my respective colleagues relied upon in many occasions, and determine what is most appropriate for them, their care and their quality of life. We are not saying that medicine should be unlicensed or have to be licensed, but there should not be a right which undermines meaningful discussion and judicial debate as part of individualised care for the best interests of children. Where we cannot say with great or indeed any certainty that a treatment will serve a particular group, we must prioritise each child. Thank you.
Many congratulations to both teams for that brilliant debate. I think what will be best now is if we go ahead and have a bit of reception, let Lord Carloway undertake the necessary deliberations, and when you're ready we can reconvene and hear the decision. But many congratulations to both teams again.